If the court is well known with the fact of the case, I would like to proceed with my arguments. Much obliged. Firstly, I would like to raise the issues that has evolved in the case. The first issue is whether the accused is liable under section 307 of IPC. The second issue is whether the accused is liable under section 498A of IPC. The third issue that is raised in the case is whether the accused is liable under section 494 of IPC. And the fourth one is whether the accused is liable under the Double Prohibition Act 1961 of Domestic Violence Act in Maintainable. I will be addressing the first issue, and the other three issues are going to be addressed by my co-counsel. The counsel seek permission to argue. Much obliged. Whether the first contention I would like to raise is whether the accused is liable under section 307 of IPC, which says attempt to murder. The learned counsel most humbly submit that the accused is not liable under section 307 of IPC due to some grounds. The first one is lack of intention. It was just a reaction of an action. It can be proved from the fact of the case that the accused took the victim to the hospital and took care of her. He had no intention to do that. It was just an unfortunate accident. Yeah. I'm sorry, sir. Will you repeat? Yes, sir. In some way, yes. I'm just saying that it was happened just because of the action of the petitioner. It was just a reaction. As we can say, every action have a reaction. That in that means I'm saying. The important point in 307 of IPC is that he should have some intention, but he is not having an intention. It was just happened because of the his extreme temper. Yes, sir. Just in a reaction. No, sir, I'm not agreeing in that way. I'm just saying he just threw the statue of stone just in the reaction. Because when the petitioner threw the shoe, yes, sir, he threw the statue. Yeah. Because it also mentioned in the fact of the case as well. Now I would like to present a citation as well. In Atwari Mandal versus State of Jharkhand, Atwari gave a first Atwari Mandal versus State of Jharkhand. Okay, sir. Hanji, sir. Yes, sir. Much obliged, sir. Atwari gave a first blow on the head of the injured person during the quarrel between the victim and him. He also gave some grievous injuries on the hand and leg of the victim. He was charged under section 307 of IPC, but his conviction under 307 was kept aside by the Honorable Court of Jharkhand by stating the reason that the accused accompanied the victim to the hospital as well, and several persons were present at the place of that time, but no one tried to prevent accused from assaulting the injured person. If he had any intention to kill them, he could easily kill. And the fact of the present case is quite similar to the fact of the case of Atwari Mandal. In this case also, the accused accompanied the victim to the hospital as well, and he had no intention to kill her. It was just in a sudden reaction, in a sudden provocation which he did. So this fact proves that he didn't have any intention to kill her. The second ground I would like to raise is sudden provocation. On 19th November 2017 at 9:30 p.m., a quarrel happened between the victim and the accused. The victim threw a shoe on accused, and she also used some intolerable act, words and languages, and accused in sudden provocation threw the statue of stone, which unwillingly struck on her head. But the act was done totally unintentionally, so accused should not be liable under this section. Harrison Gore, in its Panel of India, Volume 3, page number 3129, a man can't be convicted for an attempt to murder or to commit any other offence if the evidence discloses that he was in rash, negligent or reckless. I would like to present a case as well in this topic. The Muthus versus State of Tamil Nadu. The case threw waste and garbage into the shop of the accused. A scuffle ensued during which the accused picked up a knife from the table and inflicted injury near the chest. The Supreme Court held that throwing waste and garbage inside a house or shop is certainly grave and sudden provocation. And in the present case as well, the victim also threw the shoe, which leveled up the temper of accused, and the act was happened unfortunately. The third point I would like to raise is opportunity available to accused. In the case of Kaluram versus State of Assam, the court held that there are various circumstances from which the intention can be gathered. Some relevant considerations are the nature of the weapon used, the place where the injuries were inflicted, the nature of the injury caused, and the opportunity available for the accused. And in the present case, the accused had full opportunity to murder the victim at the time when she fell unconscious, but the intention of accused was never ever of murdering her. So in spite of taking advantage of that moment, the accused took her to the hospital and for her cure. And now, on the basis of all the above grounds, it is totally proved that he had neither intention nor motive to kill her or to commit such a crime. And now, if the bench is agreed, I would like to further seek permission to call the co-counsel to address the another issues. Yes, sir, it not. Yes, sir.
Intention or knowledge.
हाँ जी सर. Okay. Okay, sir. Actually, I'm sorry, sir, but I'm not able to answer this question. It will be addressed by my second co-counsel. Thank you, sir.
A very good known to the bench. The counsel seeks permission to proceed the rest of the issue. Much obliged. The next issue is whether the accused is liable under section 498A of Indian Penal Code. The learned counsel most humbly submits that accused is not liable under that section because the accused only wanted some help in his business from the parents of complainant in order to give high life standard to complainant according to her status. But the accused frustrated when there was a complete refusal to help him from the side of complainant. This frustration became the reason of quarrel between both of them, and they started abusing and assaulting each other. This point also be noted, my lord, that in spite of making any complaint to authorities, complainants also started hitting back accused, and it is a general principle of law that nobody can take laws into their hands. It is also a general principle of natural justice and equity that he who comes with into equity must comes with clean hands. This is clear from the Moot problem that the complainant used this section as a weapon against her husband, and the whole story told by her is fictitious and baseless. It was also held in Arnesh Kumar versus State of Bihar. Supreme Court shows a serious concern about misuse of this provision. The court held that 498 is a cognizable and non-bailable offence, has landed a dubious place of pride amongst the provisions that are used as weapons rather than shield by disgruntled wives. The simplest way to harass is to get the husband and his relative arrested under these provisions. that there is the accused is not liable under this section, because merely on the basis of incomplete facts, accused cannot be convicted under the section 498 of Indian Penal Code. If the bench is satisfied with the arguments, the counsel seeks permission to proceed further. Much obliged. The next issue is whether the accused is liable under section 495 of Indian Penal Code. No, sir. But we have a reason not to return in this section in the memorial. Okay. 495. 495. Firstly, 494 is a non-cognizable offence, and it is also clearly mentioned in section 198A of CRPC. Is the counsel audible to the bench? Yes. Firstly, it is also clearly mentioned in section 198 of Criminal Procedure Code which says about no court shall take cognizance of an offence punishable under chapter 20 of Indian Penal Code except upon a complaint made by some person aggrieved by the offence. So in the present case, the complainant has not yet raised any complaint against this. And the point also 495 and 494, under 494 and 495. On this point, I would like to say that that when the charge were framed, the arguments done on framing of charges, and charges was only framed under section 307 and 498A, and that means there was no sufficient yes. But sir, complaint was not made yet by complainant, and charges were also not framed by the court. This is then it's so then sir, it is also clear from the facts that the first marriage of accused is not clear. The status of first marriage is not clear, whether she is alive or not, she is divorced, deserted. This can be shown from the facts that even the first marriage of Ramesh not made any complaint against Ramesh, and since 12 years had been passed from the date of her marriage, and even Reena not made any complaint. So this is only a presumption that sorry sir. It is shown from the facts he is legally married to one Rupa, but it is not given under the but it is not shown from the facts that his $376. Yes, sir. Just a second, sir. Just a minute, sir. Much obliged. Sir, there is no clear proof from the facts that there is a cohabitation, sexual intercourse between accused and complainant, and this fact can be proved. It's only 2 years they have living together, and that time also they used to quarrel all the time. This point can be justified further arguments, but now here 370 the accused is not liable under 376 because there is no direct proof to prove that there was a sexual intercourse between both of them, and this can be inferred from the fact that they do not have any children, even 2 years of their marriage. So, yes, sir. It's only sure, sir. Yes, sir. Hitting backs. But sir, it is mentioned it is done under only sudden provocation, and it can be proved that Ramesh only threw a stone which was unwillingly struck on her head. Unwillingly struck. Because it is clearly mentioned in the Moot problem. So okay, sir. Much obliged. The next issue is whether the accused is liable under under Dowry Prohibition Act and DV Act. Then the Learned Council most humbly submits that it is not accused is not liable under that particular act because it is not difficult for Reena to make complaint under Domestic Violence Act or Dowry Prohibition Act because she is educated and also economically independent, as well as she belongs to a very rich family. There is also helpline number available to make complaints, but she didn't make any complaint to authorities. And this somewhere shows that Ramesh is not liable for dowry because Moot program also discloses that there was only a demanding of bungalow etc. for them. For them, what may be noted, my lord, that it only means that he wanted to secure their life. It is also mentioned in Times of India that every year more than 10,000 complaints of dowry harassment are found to be false. So Reena is only trying to harass her husband. So now the council seeks to permission proceed with prayer. Sorry sir, you are not audible to me. Sorry. No, Ramesh not filed any because there is Ramesh is absolutely no. Sorry sir, please complete your question. Please repeat your question, sir. It is not clear from the particular moot preposition, sir. Which I absolutely say that hitting back is not a good option. She can make complaints to authorities. The council seeks to proceed with prayer only. Sorry, sir. Therefore, in the light of issue raised and argument advanced and authority cited, may this honorable court please to acquit the respondent from charging of offence under 307 and 498A and 495 and also from charges under Domestic Violence Act and Dowry Prohibition Act, and pass any other order which may deem fit in the interest of justice, equity and good conscience. It was present before the court.
अगर पूछ रहे हैं
आंसर दे दो।
नहीं कर सकते हैं क्या?
अगर बोल रहे हैं तो विद रिक्वेस्ट
मुथु वाला भेज दियो इस पे। ये बोल रही हूँ कि इट वाज द कि वो एक्यूज्ड था जिसकी वजह से विक्टिम बच गया, वो टाइम पे हॉस्पिटल लेगा तो ही बचा है।
वो लाइन क्या पे जिसमें लिख रखा था आज की बंगलो फॉर देना shoe is not a big deal. But as I presented the citation of Muthu versus state of Tamil Nadu, it was totally sure that throwing garbage is not that much a big deal. But it depends on the person to person, temper of the person. He was already frustrated because of the quarrel happened between the victim and the accused, and it was just because of the temper. When he threw the shoe, he just the sudden provocation through the statue of stone. It was not pre-planned. It was just a reaction of an action. It depends on the temper of the another person. And the second thing he mentioned that asking for dowry as dowry, and bungalow and demanding for bungalow, as the site already in the Moot problem it is mentioned that he demanded bungalow for them. That means clearly state that he just wanted to make her feel as much she feel or live in the time when she was unmarried, because she belongs to a richer family, and now she belongs to and now she is living with a person who is from mediocre family. He demanded for a bungalow for them, not just only for him. And yeah,
the point may also be noted, my lord. The point may be also noted that it was the sorry sir.
sir, it's not about demanding a dowry. There is no word used like dowry in the whole proposition. It just he wanted to make her feel that lifestyle.
Sharing property is
Okay, sir. Okay, sir.
No, sir.
Sir, thank you for also highlighting the uses of dowry word. But sir, the thing is, I'm not saying about that. I'm saying about he demanded something for them, not for himself only. He demanded for them. So providing a lifestyle is not a big deal.
The Learned Council like to say that share in property is a right of Reena, and Ramesh only to ask her to take her share for their better lives.
Because he was feeling like he was a mediocre family, and he just wanted to make him feel as she was feeling when she was unmarried.
It is only a matter of fact which are not cleared. It only say about demanding. It is not cleared about that demanding, and it not show the Reena side.
And so one more point I would like to highlight that the other counsel said that it was intention to kill her, but as we have read from the fact of the case, it was not his intention to kill her. If he had that, then why he taken her to the hospital? And he said that hospital is not a necessary, or not only the only factor from which we can say that he is not applicable for 307 of IPC. But
The point may also be noted, my lord, that it was the accused who saves the
बाद में भी मार सकता है।
सर
But it was clear from the facts that it was the accused who saves the life of petitioner. If he could not take her to hospital.
पहले परमिशन लेके फिर
I'm sorry, sir. Will you please repeat it again? I'm from BLB first year. Second term first year. Yes, sir.
I am from BLLB 10th semester, final year. Yes.
Sir, I am from final year BLLB. Sir, sorry sir, voice is breaking. Yes sir. Sir, it was a collective effort.
Thank you, sir.
Thank you, sir.
Thank you sir.
हाँ? क्या बोले सर?
Thank you, sir. All right. मैंने तो कर ही दिया।
इसमें देख लो।
रखना।